my talk for the next 20 minutes or so will be on secret commissions in the energy industry. Truth, but not the whole truth. And this is essentially a talk about the factual basis of these energy claims that have been brought by businesses against brokers and suppliers, but it's also in the context of the cause of action being bribery and breach of fiduciary duty. And I'll be reviewing some of the case law, most recently the Wood case from the Court of Appeal from last year, which was certainly an interesting development in that cause of action. So, first, what is the claim? What are these business energy claims? Well, in most cases, it will go like this. A business will receive a cold call from somebody purporting to be able to give a better deal. These energy brokers, or sometimes they refer to themselves as third-party intermediaries, they're totally unregulated, but approach businesses with the idea of providing a hassle-free service. They will get a letter of authority from the customer. They would go to their current supplier and obtain current usage, current information on their contract. They'll then go to other potential suppliers and ask for potential quotes. What would this particular business be offered based on their location and their usage? And energy contracts vary significantly based on location and a number of factors. So they're all bespoke contracts. They'll then approach the customer and come back and say, here are a number of contracts, or here is one particular contract. They'll often say, this is the one that we think is the best deal for you. It'll save you some money. They'll also promise to protect against future price increases, no doubt, by promising a future deal where they'll arrange for fixed costs going into the future. And it's always suggested that it's time sensitive, so you sign up as quickly as possible to avoid this contract increasing in price. What is happening then in the background, though, is that the customer isn't directly paying for this service. They're being approached, and to them, they consider it a free service. Where the broker gets their money, though, is by agreeing with the supplier to be paid commission. And that's usually per contract, depending on the size of the contract, and a number of factors. And sometimes there are pricing matrices where they, depending on a particular type of contract, will be a different type of uplift. But essentially, this is agreed without the customer's knowledge. And what will then happen is the supplier would then add that commission into the contract that is then presented as a price to the customer. So the customer has no idea that actually they are paying a commission, and that is applied through the contract price that they're paying, and that is going indirectly to the broker. It's going to the supplier and then getting passed on. They're not involved in that negotiation between the supplier and the broker as to what that uplift would be. So as an example, if a unit price of electricity was 10 pence per kilowatt, they might agree a 1 pence per kilowatt uplift between the supplier and the broker, and then the customer gets presented with an 11 pence per kilowatt hour price. What is key here, really, as I say, is that the customer is believing that this is a free service, but in fact, because it's built into the contract, they are indirectly paying for the service without actually being able to understand what that price is. So, applying that to the cause of action, as I say, being bribery. The first case that I've listed and I summarised in the handout is Industries and General Mortgage Co. Limited and Lewis. I say it's summarised. It's not. I've put a particular quote which summarises the cause of action very neatly. And there's three elements that are identified here. Firstly, the person making the payment makes it to the agent of the other person with whom he is dealing, i.e. the person making the payment being the supplier makes it to the agent, i.e. the broker. 2, that he makes it to the person knowing that person is acting as the agent of the other person. So that is the supplier knowing that they're making that payment to a broker who they know acts on behalf of a customer. And that no doubt will come about given there is a letter of authority that will have to be presented before that supplier deals with that broker for a particular customer. And then finally, 3, he fails to disclose that to the other person with whom he is dealing, that he's made that payment to the person with whom he knows to be the other person's agent. Essentially, there is no disclosure. So those are your 3 causes of your 3 elements to the cause of action. And there's a line of authority starting with Wilson and Herstanger talking about, well, what's needed to be aware? What do you need to know to be aware that there is this commission? What's enough to negate this secrecy? Well, in Herstanger, there were essentially there were defendants who were in arrears who sought further credit to avoid possession proceedings. They then defaulted on that loan and sought to defend the action from the lender by asserting that, in fact, there was a secret commission being paid that they weren't aware of, and therefore they wanted precision of that agreement. Now, what the Court of Appeal said was that that relationship between the broker and the defendants was obviously a fiduciary one, and they talked specifically about how the broker's interests were in conflict with the defendants, i.e. the broker wanted to get a deal that would get them the best commission, their company the best commission, but the defendants wanted the best deal for them. They wanted the cheapest deal, and that was a conflict that arose. What they said on disclosure was that there was a requirement for full disclosure, and therefore, if commission was paid but it wasn't secret, then there's no wrongdoing. And that burden of proving disclosure is on the person as seeking to rely on disclosure taking place. So if the energy broker claims, it would be the broker or the supplier. Interestingly, in Herstanger, the Court of Appeal said that where a party is said to be more vulnerable and unsophisticated, it's more likely that more disclosure is required. And in Bowstead and Reynolds, the Court of Appeal quoted from that and said that, in essence, where a party doesn't pay for a service and leaves them to find their payment elsewhere, they can't object to the fact that they don't know exactly how much they were paid. And that's essentially a case where a broker, if he's not paid, he or she aren't paid directly by the customer, the customer must know that that broker is getting paid somehow. But depending on how common that arrangement is between the broker and the supplier, if it's a standard arrangement, it's more likely that if that's easily ascertainable, you don't need to find out the precise particulars. But where there is no usage, no trade usage, then you may need more specific disclosure. And in Herstanger, the term of the contract said that the commission may be paid. Not that it was in every case, but that it may be. And that was held to be a halfway house. It was enough to negate secrecy. If you're told something might happen, you can't object to the fact that it does. But it wasn't enough to negate the duty to obtain informed consent. And it was described as a halfway house case. And it was no more than a breach of fiduciary duty, a half-secret commission case, and therefore the remedies were equitable only. And in that case, they didn't allow rescission, but they did allow a recovery of commission amount. So developing on from that is the next case, McWilliam. McWilliam and Norton Finance. That was a PPI claim whereby, in that case, the judge held that when considering Herstanger, despite the fact the transaction was non-advised, there was still a relationship of trust and confidence, which gave rise to the fiduciary duties. But comparing those particular claimants to Herstanger's claimants, they were held not to be as vulnerable or unsophisticated. And the comparison was really that in Herstanger, the borrowers were approaching a broker to lend in the non-status lending market, which is a market for those who can't generally obtain credit through usual means. But they were still held to be not financially sophisticated and still, to an extent, vulnerable, but not to the same extent as Herstanger. They were described as being of modest means. They had credit problems in the past, and they had a substantial debt that needed to be dealt with through a loan. And interestingly, when the judge had considered Mrs. McWilliam's evidence, the judge said that despite the fact that that one can show reasonable competence in handling relatively straightforward transactions, they might lack what's called financial sophistication. Despite the fact that the claimant had said, I'm not particularly sophisticated, repeated that, but as I say, the judge held that she was still reasonably competent, but lacked that financial sophistication. So what do we take from that? Well, the judge in that case clearly compared the claimants and clearly judged the standard of how vulnerable they were or how sophisticated they were when considering whether or not full disclosure had taken place. And in that case, it was still held that they were still too vulnerable and too unsophisticated to mean that there was still disclosure required. The next case is Medstead, whereby the main comparison, again, it follows on from the Herstanger and McWilliam cases in that these were much wealthier and more experienced investors who the Court of Appeal said were far more sophisticated. Therefore, the amount of disclosure required simply wasn't needed to the same extent. So even though there was no common trade usage in the types of transactions that they were looking at, the particular investors were held to be sophisticated enough so that full disclosure had taken place. So there is clearly a focus on what type of claimant they are, how vulnerable they are, how sophisticated they are, and then in terms of energy claimants being businesses, it's unlikely, I think, that many businesses will be held to be vulnerable in an energy claim, but how sophisticated they are is another question, and that might change based on size of the business. It might change based on the number of premises they have, and it may also have some impact. The McWilliams case may have some impact in terms of matters of reasonable competence but not financial sophistication, i.e. anyone can go and arrange an energy contract, but they don't know the sophisticated ins and outs of the energy industry such that they may not be held to be sophisticated. That's certainly how I interpret that. But the case law appears to have a focus on both elements, vulnerability and sophistication. We don't know yet what will happen if one exists and the other doesn't. And so that's something that will probably need to be tested. Finally, Wood and Commercial First Business, which is the Court of Appeal case from last year. This was a conjoined appeal from the High Court with Pengelly. And there was commission paid to each broker, and the Court of Appeal undertook a very broad discussion about what common law bribery really was, and what the authorities have said in terms of the fiduciary duty that's required. So it's a really good case to read to give a good overview of this cause of action. Importantly, Wood distilled what type of fiduciary relationship is required in a bribery claim. It was simply a duty to provide disinterested advice or recommendations or information that is required in this type of case. So simply a duty to be honest and impartial. Importantly, for energy claims, the payer and the payee of the bribe were repeated to be then the fact that they are primary wrongdoers, both payer and payee. So in terms of claims against brokers and suppliers, they are jointly and severally liable under a claim for a bribe. They're not viewed as an accessory. And they said that was the extent of the fiduciary relationship that was needed. There was also a good discussion on what remedies would be applicable. The first was that you could have a return of the bribe as monies had and received, and that was without needing to show any loss at all. And that really comes from the fact that the courts view bribery as something to seriously be discouraged. It's something that is essentially more of a deterrent than anything. You can have that, or you can have losses flowing through the tort of deceit, so you have to prove what losses would arise, but they're an either or. You're additionally entitled to rescission as of right, not as a law. Not as an equity. So you have the claimant has the right to elect whether or not to rescind the contract, and that's obviously subject to counter restitution. And in an energy claim, again, the question might be, well, how do you give counter restitution? And that's certainly something that I think will cause some arguments. That in Wood as well, the particular clause was similar to Herstanger in that it said there may be commission, but it then said we'll tell you about it if there is any commission paid, and they weren't told about it, and therefore on the reading of that particular clause, it was held to be a fully secret claim. The impact of Wood on Herstanger isn't yet clear, given that it was somewhat dodged in terms of the half-secret, fully secret discussion. So it's not yet sure whether Herstanger survives Wood. One could argue that Herstanger was concerned only with half-secret claims, which are breaches of fiduciary duties only and not bribery, and therefore that survives separately, and so the fiduciary relationship you need to show is still the same. But it also seems to me that given how similar the causes of action are and how really the only difference ends up being the remedy, I wonder whether Wood would actually apply in terms of the overall cause of action. Again, it's something that needs to be tested. One quick point on limitation, which is that essentially the point is that it's a 6-year limitation period. It's from the date of receipt, so that's a really important date to discover, and that can cause problems for claimants who obviously don't know when commission was paid, given that it's entirely secret. It's a matter between the broker and the supplier, so that might need some disclosure, potentially pre-action to consider whether or not a case like this might be possible to proceed. And that's the same for the supplier as well, so it's that 6-year period. So I've set out in the handout and here what I think the summary of the cause of action is, and as I say, that's setting out the simple duty of honesty and impartiality to be first proved. Whether or not a commission was received, well, this is something, again, that might seem straightforward, but you might need pre-action disclosure to understand this, given that it is, as I say, a secret commission. Whether full disclosure was given, and that's, again, considering the authorities we've looked at. In terms of getting the supplier on the hook, whether or not they knew about the broker and the extent that that would make them in law an agent or a fiduciary. So that's finding out what was disclosed, what letter of authority was disclosed, etc. And then the 2 points on remedy. So that's a kind of brief overview of the cause of action and how that might apply to these cases. The final thing to say is there has been very recently from OFGEM a microbusiness strategic review whereby they essentially said that these broker commissions need to be disclosed in the contract from October 2022. That means essentially, I imagine these types of claims in the energy industry in particular will probably have a long stop. They'll have a point at which there are no more, because all these brokers will be changing their views and their approaches. But there is clearly a lot of historic non-disclosure that will mean that there will probably be a lot of these cases going forward.